Charles, I want to ask you about this case. There are two ways for Garland and Samuel to defend. One is to defend on the facts to try to get an acquittal, and the other is to keep in mind that this is a death case. So with your work for them, they have to look at this both ways, right?
That's correct. That's absolutely right. I think, as you know, in any death penalty case, the foremost obligation is to try to spare your client's life. So we've always approached this both from the guilt-innocence phase and also looking at the mitigation case, in the worst-case scenario. When
you're investigating for that purpose, do you do a lot of work as an investigator to find out about the prospective jury pool?
In this particular case, I did not do a lot of work in that regard. I have in the past in other cases, but that was really not a focus of my efforts in this case.
And your efforts then were primarily focused on dealing with the witnesses both for and against your client, I assume then?
That's correct. Again, my focus has been on the guilt-innocence phase of this case in terms of evaluating the testimony of the witnesses that we knew about, and also in terms of trying to identify other witnesses that may be beneficial to the defense, impeachment issues with regard to the prosecution's witnesses. For instance, with Mr. Harwood, there have been a multitude of statements, written, videotaped interviews, etc. over the years, and there's been a tremendous degree of inconsistency. And particularly as it relates to Harwood and Ms. Trahan, who's going to testify today, doing the analysis on the consistency, or in this case, a fair amount of inconsistencies between both of their versions of what occurred. It was highly significant to determining the credibility of both of those witnesses.
Indeed, and they're very powerful. I want to bring Joe Tacopina into this conversation, my guest, my very, very dear friend, and one of the great trial lawyers in America who wins cases that nobody else could win. This is the kind of case where some defense lawyers may say, look, it's impossible, I can't win this case. These two lawyers never think like that. Right. These lawyers think there is always a way, and they were persistent for years in that 4-year extradition proceeding to keep their client from facing the music here in Georgia. But this is a hard case, Joe.
It's a hard case, I mean, because you have both the circumstantial evidence, which is powerful in and of itself, and then you have the cooperator testimony. And the witness today, the ex-girlfriend of the alleged hitman, is, I think, the most devastating witness, because unlike the alleged hitman and the jailhouse informant, who have all sorts of built-in credibility issues and have issues regarding, you know, their own, desire to get out from under, this is a woman who was sitting in her living room, really with no axe to grind, doesn't seem to really know anyone on a personal level, and doesn't have a motive to really want to come forward. It's not trying to get out from under a prison sentence. She's going to corroborate the hitman, who's going to corroborate the circumstantial evidence. That is when it gets tough. The dots start connecting.
Indeed they do. And Charles Mittelstadt, let me go back to you, because you've actually interviewed this woman. What kind of a person is she?
Well, let me first tell you about the circumstances of the interview.
Please.
This witness was made available to us by the prosecution. The interview took place over the course of 2 days. The setting was somewhat uncomfortable in that no less than 4 members of the prosecution team, if I recall properly, at least 3 of the DAs involved in this case and at least 1 investigator sat in on the interview, which is not conducive to the environment where you can foster any type of rapport with the witness or really get into any detailed exploratory type questioning with the witness for fear of tipping your hand as to a theory or a particular course of questioning that you're going to go down. So it was very restrictive in nature. My sense was that the prosecution had spent a fair amount of time with this witness preparing her. She was somewhat, she was guarded in her questioning, in her answers, and frankly, the interview process didn't necessarily net a whole lot of information. We are going to rely more on what we know from her statements and from her interviews with law enforcement on cross-examining her more so than what we were able to ferret out of her own interview process.
Joe Tacopina, you contributed to the book that I edited called Take the Witness, Essays on Cross-Examination, and one of the things that you are known for is being a great cross-examiner. How do you handle a woman like this?
Well, again, assuming she has no real skeletons in her closet, that she's not a bad person, she hasn't been convicted of crimes,